Well, good morning, everyone, and welcome back to Aj111 Criminal Procedure. My name is Tony Farrar, and of course, I am your instructor for this semester. This morning's lecture is going to cover Chapter 4, where we are going to look a little bit further into search and seizure, but more specifically, stop and frisk. So with that being said, let's go ahead and jump right into today's lecture. Again, I'm going to try to keep it within the 60-minute time frame, and if I don't think that's possible, I will break it up into two shorter lectures just the same way that I did in the previous chapter, Chapter 3. So, what do we hope to learn from Chapter 4, talking about stop and frisk? Well, one of the things we need to know is the basis for stop and frisks in the text of the Fourth Amendment, meaning how do those two things fit together? We would certainly like to understand the difference between an investigative Terry stop and an arrest. So is there a difference between those two? Number three, to know the definition of reasonable suspicion and the various factors that police consider in determining whether or not there is reasonable suspicion in a particular case. Number four, define the circumstances under which an informant's tip constitutes reasonable suspicion, meaning can someone just call up, provide some information to law enforcement, and will that information in and of itself be enough to rise to the level of reasonable suspicion, or does there need to be more? Number five, know the role of drug courier profiles in reasonable suspicion stops. Number six, appreciate the significance of race in the police determinations of reasonable suspicion. Next, state when Terry stops allow the movement of suspects, the length of permissible seizures, and the allowable intrusiveness of the methods used to investigate suspected criminal activity. Number eight, know the constitutional authority of the police to require drivers as well as the passengers in a vehicle that they detain on, let's say, a traffic stop to exit the automobile and the circumstances under which the police may subsequently frisk the driver. Number nine, know the circumstances under which the police may frisk a suspect and the overall scope of a Terry stop and frisk. Number 10, know the justification for frisking passengers in an automobile who are not suspected of criminal activity. That's an interesting one. Number 11, know when the police may search the passenger compartment of a vehicle. And then finally, number 12, know the legal test for the seizure of narcotics as written in a case law by the name of Minnesota versus Dickerson. All right, so a lot of information. So let's go ahead and start with a kind of a scenario, if you will, like a little case study, but a little scenario to kind of get you going. So Officers Nolan and Harvey were driving the last car of a four-car caravan converging on an area known for narcotics trafficking in order to investigate drug sales. Now, Officer Nolan observed the suspect, and in this case the last name is Wardlow, standing next to a building holding what appeared to be a somewhat small opaque bag, opaque meaning that you can see through it. And as the officer noticed this, Wardlow, the suspect, looked in the direction of the officers and then started running. So basically, he fled. Now, Nolan and Harvey turned their car southbound and watched the suspect as he ran through the area out into an alleyway where they were eventually able to corner him on the street. And then Nolan exited the vehicle and ended up stopping the suspect. Nolan immediately conducted a protective pat-down search for weapons because in his training and experience, it was very common for there to be weapons in the near vicinity or on the persons that are involved in narcotic sales. Now, during that frisk, Officer Nolan squeezed the bag that the suspect was carrying and felt a heavy, hard object similar in shape to that of a gun. The officer opened the bag and discovered a .38 caliber handgun with 5 live rounds of ammunition inside, and the suspect was arrested. So, if you recall from our previous chapters, what level of burden is necessary for police officers to search and or arrest a person, without kind of reading into the Terry versus Ohio case yet, if you recall. What is the basic rule of thumb when it comes to searching and arresting an individual? And if you said probable cause, you're right on track. But now we're going to talk about stop and frisk and one of the famous landmark cases, Terry versus Ohio, that's going to add one little curveball into this whole kind of thing that we're going to talk about. So let's jump into it. So the text of the Fourth Amendment appears to indicate that a seizure and a search of an individual must be based on a warrant, but certainly must be founded on probable cause. Now, we know from previous chapters that we can search, even though the Fourth Amendment prefers searches to be done with warrants. We know that there are times that we can't always get a warrant in the field as we're actively investigating, so we know that there are exceptions to that particular rule. But remember that the Fourth Amendment also specifies the issue of probable cause. Now, in 1968, in the case of Terry versus Ohio, the U.S. Supreme Court confronted the issue of whether or not individuals may be lawfully stopped and frisked under the Fourth Amendment based only on reasonable suspicion. So this kind of goes a little bit against what we've already learned. We know typically to search or to get a search warrant, okay, you're going to have probable cause. For a warrant, you're going to have to spell out all of that factual information in an affidavit to the judge in order to convince the judge that you have probable cause. In order to search an individual's vehicle or search somebody on the street, you're going to have probable cause, and more so, you're going to need probable cause. And yes, I'm at home and the phone is ringing in the background, so sorry about that. You're going to need probable cause in order to make that arrest. So again, in 68, we have this Terry versus Ohio case that kind of changes things a little bit. And the court was confronted with this particular issue in this particular case. Now, this whole practice of stopping and interrogating and frisking individuals without probable cause had been part of the arsenal of local and state law enforcement officers for decades. And states like New York passed certain statutes that explicitly authorized police to stop any person who is reasonably suspected of engaging in or about to engage in criminal activity, and to carry out a subsequent search in order to protect life or limb. So kind of an interesting concept that we have going here right now, right? And in 1967, the President's Commission on Law Enforcement and Administration of Justice recommended that in view of this, of the overall rising crime rates, state legislators should provide the police with some type of clear direction or authority to be able to stop, frisk, and question people on a standard a little lower than probable cause. And we've looked at that standard before on kind of a pyramid type scale, if you will, or even on like a step ladder type scale. Now, civil libertarians objected that in the past, seizures of persons on that burden less than probable cause had basically been employed just to harass the homeless or minorities. And law enforcement, however, law enforcement authorities felt that it would be extremely unreasonable to tell an officer working the street, working the patrol beat, that he or she is prohibited from stopping a person who the officer suspects is engaged in criminal activity. So you can see there's a little bit of catch-22, because part of your job is to look for things that look out of the ordinary, that look suspicious, and that a reasonable person out there might look at things in a similar situation. Now, if you want to watch a couple of videos, you probably watched one or two videos on stop and frisk in the module, in the introduction portion of the module, but I also have a link down here at the bottom of the page titled Stop and Frisk, and you can go there and you can watch a little video on some of the issues related to stop and frisk as well. So kind of continuing on the other hand, Justice William Douglas warned that abandoning the probable cause standard was in fact a step down a totalitarian type path, and that this could lead to the evaporation of civil liberties, meaning that that law enforcement could just ignore some of those rules and not do their searching or stopping, etc., at that burden level of probable cause, and that we might go down that slippery slope, if that kind of makes sense. And that's, it sort of does make sense. So the Supreme Court, in this case, reasoned that requiring an officer to wait until he or she had developed probable cause in certain circumstances would not only place them at harm, but it would place society at risk of harm. So we're going to kind of take a look at this stop and frisk issue a little bit deeper. Now, the Supreme Court in the past had really resisted efforts to weaken Fourth Amendment protections and had held that a reasonable search under the Fourth Amendment required a warrant founded on probable cause, or on probable cause in those instances in which time did not permit, remember I talked about that, the police to obtain a warrant. And there was a case that kind of goes along with that. It was Henry versus United States. It's a little bit old. It was 1959. So again, Terry versus Ohio, this case really breaks new ground, or it broke new ground at that time, and employed a balancing test to establish that brief investigative stops of people may be based on only reasonable suspicion. And again, the court explained that field interrogations are in fact essential for investigating and detecting street crimes. And these stops are distinguished from custodial arrests by their narrow or shorter investigative purpose and limited intrusion on individual liberty, and therefore may be based on the lesser standard of reasonable suspicion rather than probable cause. Now, this Terry case took the additional step of holding that an officer is in fact entitled to conduct a frisk to protect themselves in those cases in which he or she possesses reasonable grounds to believe that a person is armed and is presently dangerous. So again, it's new ground here. Terry versus Ohio was actually the first case in which the Supreme Court approved a search and a seizure of a person in a criminal case under the Fourth Amendment based on only reasonable suspicion. And the reasonable suspicion standard, again, was derived from balancing the need for swift action by an officer to investigate things we do, to detect or to prevent a crime, against what the court would consider to be a narrow or modest intrusion of a person's privacy. So hopefully all of that kind of makes sense. So now we want to look at some of the topics that we're going to be reviewing as it relates to the law of stop and frisk. The first one is going to be reasonable suspicion. We're going to take a look at that. And this is where individuals may be seized or stopped, again, based on reasonable suspicion. And we'll define these a little bit further as we go through. Informants and hearsay. The police may rely on informants and, in some cases, hearsay to reach a conclusion that there is reasonable suspicion to stop someone. I mean, and sometimes these are kind of gray. What if you were walking out on the street and you're working your patrol beat and someone flags you down, which means they're waving at you, and you pull up to them and they say, "Hey, officer, this person over there has a firearm under their jacket," but they don't want to get involved or anything. They just want to give you that information. Is that enough for you to go over there and investigate further, to actually maybe even detain someone or search a little bit further? So all of these things, kind of put them together as we're talking about these. Next would be race and reasonable suspicion. A stop may not be based solely on race, ethnicity, or religion. Now, these characteristics, so keep this in mind, these characteristics may constitute one factor that, along with other factors, will build up that burden to reach that reasonable suspicion. Okay, but it can't be the sole factor. All right. Next, the scope and duration of a Terry stop. Terry stops, and when I say Terry stops, that's kind of a short version for the case Terry versus Ohio, or the stop and frisk. Those are kind of synonymous, if you will. So Terry stops are in fact limited in the permissible movement of a suspect and the duration, meaning the length of time that you can detain someone. So there are some limitations on a Terry stop, and we'll look at some of those. Car and Terry stops. The police may direct the driver and passengers to exit a car during an investigative stop, and there's always a lot of questions about that, and hopefully we'll cover those as we go through the chapter lecture. Frisks. The police may conduct a frisk of a suspect's outer clothing for weapons, and this has been extended to passenger compartments and frisk for drugs. So as we're talking about vehicles, and you get a little bit more, well, we'll talk more about search and seizure and vehicles and how they differ a little bit, and you get a little extra leeway because vehicles are mobile, etc. But we'll talk a little bit more about that. So again, reasonable suspicion. Remember, Terry versus Ohio is in fact, or was, the first case in which the U.S. Supreme Court approved a search and a seizure of a person in a criminal case under the Fourth Amendment. Again, the stop is based on reasonable suspicion. And if you look down at the bottom, just as a little bit of general reminder, reasonable suspicion is the amount of evidence that an officer needs to frisk somebody. But really, reasonable suspicion, remember, it's also, you can also call it articulable suspicion, meaning that you can articulate certain facts that lead you to believe. Okay, so that's kind of how that comes along. And then probable cause, the burden is a little bit higher. Okay, because that's typically what you need to search or to get a search warrant or to arrest. So it talks about here the amount of evidence that an officer needs to arrest someone. So a little bit of probable cause, reasonable suspicion comparison. Now, a little more on the balancing test as it relates to reasonable suspicion. The reasonable suspicion standard was derived again by balancing the need, sorry for the typo there, for swift action by law enforcement to investigate and detect crime against that narrow or that modest intrusion of individual privacy. And a little bit more, the facts relied on by the police officer are to be judged against the objective standard of whether the facts available to the officer at the moment of the seizure would warrant a man. The case says man, but it can be any. It's man or woman, so it's not, it's written a little bit off key, but it was written a while ago. But would warrant a man of reasonable caution in the belief that the action taken was appropriate. Okay, so again, understanding that the reasonable suspicion standard was built again on that need for balance between you doing your job and investigating and detecting, etc., versus the modest intrusion of an individual's privacy. And I threw a little graphic in here again just to kind of keep reminding you of the difference, all right, as it relates to reasonable suspicion versus probable cause. On the left, you can see the reasonable suspicion definition. It is what you need to stop and frisk a person. And on the right, you have the probable cause definition for a warrantless search or an arrest. So just kind of another general reminder. And I threw in a couple of pictures just when we talk about reasonableness. So let's just say that in this particular case, you are working at a bank and you are a bank teller. Now, we'll start in the upper left. The gentleman doing the bank robbery with the Scream mask on, which is extremely a cool mask. But if you were a teller and this individual walked in, would it be reasonable, or do you think, and would you think everybody else in your position would think that it would be reasonable that something's amiss here and that more than likely this individual was going to do a robbery, because typically, bank robbers wear masks and he's got gloves on and a big jacket. It would be reasonable to assume that, right? So look at the bottom left. Same scenario. You're a bank teller, and this gentleman comes in, and although these are all actual bank robberies, but you didn't know that until I just said that, what would you think? Is there anything out of the ordinary that you would think that this was actually going to turn into some type of a bank robbery? Look at the upper right with the young lady with the white hat. And then finally, what about the guy with the yellow baseball cap turned backwards and the glasses? Now, typically people don't wear sunglasses all the way into the bank, all the way up to the teller. But would that be enough? Is it out of the realm of reasonableness? So just to kind of get you thinking a little bit. All right, so let's go ahead and move on. I also included, when we talk about reasonable suspicion in Terry versus Ohio, and we take a little look at this case, I included a link there to the Terry versus Ohio case, so that if you wanted to go back and take a look at it, you could. And you could also find it on page 88 in your textbook if you want to read the entire case. But let's take kind of a quick look at it. So, plainclothes detective Martin McFadden, a 39-year veteran of Cleveland, Ohio Police Department, observed Chilton and Terry standing on the corner of a downtown street on a road called Huron Road and Euclid Avenue. And the men took turns walking southwest on Huron Avenue, looking into store windows and then returning to the street corner. And each of the men repeated this routine roughly 5 or 6 times. And then at one point, they were joined by a third person by the name of Katz. And then Katz then left, walked west on Euclid Avenue, and after that, he was joined, all three of them joined up again. And at this point, McFadden decided, you know what, something doesn't look right here, and he confronted the three men and asked for their names. Now, the men supposedly kind of mumbled something, at which time McFadden patted down the outer clothing and discovered a revolver in Terry's pocket and a revolver in the outer pocket of Chilton's overcoat. McFadden later explained that he had concluded that the three men were in fact casing a job for a stick-up. Now, I know that's old language, but basically casing means to watch or to look. It's typically what people will go kind of do some surveillance or reconnaissance, if you will, to see if what's happening at a location that they may want to rob. And a stick-up is another word for robbery. So again, when we look at the reasonableness here, you have three men that engage in a series of acts. Now, each of these acts may have been innocent individually, but if you put them all together, they kind of warranted further investigation, right? Where two of them meet, they talk, they look in the window, they split up, they meet, they talk, they look in the window, a third person comes along. You see kind of how that goes, and this is what the officer, what McFadden was kind of thinking about. And part of the court's decision here, now they ended up citing for the officer here, which we know, but the court actually ended up saying that it would have been poor police work, indeed, for an officer of 30 years experience in the detection of thievery and robbery from stores working in that same neighborhood, to have failed to actually investigate that type of different behavior. So hopefully that kind of makes sense. And that was one of the excerpts, if you will, from the court. Now, we all likely would agree that McFadden reasonably concluded, that although the three men were acting legally, that they may have been kind of casing or planning for a crime. However, we might get a different result by changing the facts a little bit. For instance, we might ask how many times Chilton and Terry would have to walk past the store to arouse reasonable suspicion. The case does not really discuss whether McFadden took the race or the appearance of the men into consideration. Would McFadden's decision be a little bit less persuasive had he approached a group of, let's say, business people, well-dressed, or individuals who he knew lived in the neighborhood? So there's all these other factors. But either way, the Supreme Court sided for the officer on this particular thing. And when it comes to determining reasonable suspicion, the Supreme Court provided guidance in Terry for the methodology to use in determining reasonable suspicion in future cases, right? Because remember, these are landmark precedent cases. We've heard those words before, and we know what the term stare decisis means. So also keep in mind that each situation confronting police is a little bit different. They're not always the same, and they're not going to be. And that the facts that give rise to reasonable suspicion, they really can't be, excuse me, reduced to, let's say, a set of legal rules or very specific rules, something that's like neat and linear. A lot of times these cases are determined, or reasonable suspicion is in fact determined on what we call a case-by-case basis. And that's important to understand. And that's how the court decided to look at this particular case as well. So let's look at some of the things that help determine this case-by-case basis. The first one would be, remember we talked about the word articulable suspicion. So a police officer in justifying an intrusion must be able to present specific articulable facts, meaning facts that they can articulate, write down, that together with reasonable inferences suggest that an individual had or is about to commit a crime. And when we talk about inferences, it could be a visual inference, like here you can see the outline of a firearm underneath like the t-shirt, or it could be the mannerisms or actions of an individual. An inference could be, let's say you're patrolling at nighttime and you take your spotlight and you shine it towards a vehicle and you see someone duck down behind it. What would be the inference in your mind? Why would they be hiding? Could the inference be that they're involved in some type of illegal activity? I mean, yeah, it could be. They may not be playing hide and seek from you, okay? But you can understand what reasonable inference means. The next one is objective standard. So the facts in these cases are to be judged in accordance with a reasonable person standard and are not based on what the officer personally or subjectively believed. Police officers really may not rely on a hunch, even though we have a sixth sense sometimes. You get a gut feeling, you get a hunch, but you're not supposed to rely on a mere hunch, a generalization or a stereotype. So kind of an example of a generalization or a stereotype. When you look at these two individuals, you look at the individual on the left and you look at my buddy JT on the right. That's right, he's my buddy. When you look at first look at these individuals, who do you think is involved in more criminal activity? Now, I'm just throwing it out there. Okay, I mean, because you know JT, but anyway, who would you stop if you're driving, if you're a law enforcement officer and you're driving down the street and it's nighttime, it's, let's say, 12 midnight, and you're driving down and each one of these individuals is walking by themselves, who would you stop? I'm just saying, okay? What about this? Okay, so again, you have my buddy, Taylor on the right, but who would you stop? So sometimes, so again, what we're talking about here is that objective standard. It's the reasonable person standard, not based on, what the officer subjectively believes. And again, no hunches, no generalizations, or no stereotype. Okay, because this would definitely open the door to discrimination and the evaporation or disappearance, if you will, of people's rights to be free from unreasonable search and seizure under the Fourth Amendment if we did it that way. So next, experience and expertise. So the facts are to be interpreted in light of an officer's experience and training. Now, in the Terry versus Ohio case, remember the officer, McFadden, was a 31-year veteran. So do you think he had some training and some experience of the police force and was well aware that the store that the three men were casing had been the target in recent robberies? And he probably knows, and I believe part of this came out in the case, that he worked a lot of these robbery type crimes, and he understood or he knew what casing looks like. Okay, the same thing that if you worked in narcotics for years, you would know what a hand-to-hand drug deal looks like. That's the experience, that's the expertise that you develop as time goes on. And you could take this one all the way to the very first case that we started to look at. Remember, we talked about Nolan and Harvey, and they were in a high narcotics area, and they saw an individual standing there with another individual, and one of them was holding an opaque plastic baggie. Again, if you were a narcotics officer, you would know that typically narcotics are packaged in Ziploc baggies or sometimes even sandwich baggies, etc. And those are clear, they're opaque, if you will. So again, it's training and experience. So hopefully that sheds a little light on this particular topic. Informants. Reasonable suspicion may be based on information from a reliable informant or information from an anonymous informant who provides information that is corroborated by law enforcement officers. So we'll talk a little bit more about informants as well. And then finally, the totality of the circumstances. Actually, I think there may be a couple more. But anyway, the entire factual situation is to be considered in determining whether there is reasonable suspicion. Now, courts consider factors such as whether the suspect is nervous or calm, whether the suspect is in a high crime area or not, the time of day, the number of arrests for a crime type, etc. All of these things kind of build into the totality of the circumstances. In addition, the courts consider the suspect's willingness to cooperate, or whether the person's pattern of behavior suggests that they may be involved in some type of criminal activity. So they're in that totality of circumstance, they're going to look at the person's level of cooperativeness. And then the last couple here would be probabilities and certainties. And it's important to know probabilities, that reasonable suspicion is built on probabilities, not certainties. And because you're not quite certain, remember, with reasonable suspicion. So if you define these, probability is the likelihood of something happening, and certainty is the firm conviction that something is actually the case. So, I mean, the Supreme Court, in a case that we're going to look at in a few minutes, in United States versus Arvizo, observed that while each of the factors relied on by police officer viewed individually, particularized, and on an objective basis for stopping a vehicle, making a stop, etc., undoubtedly was susceptible to innocent explanation. Taken together, however, they formed a objective basis again for stopping the vehicle in this particular case. So even the Supreme Court talks about probability, not certainty. Okay. Now, again, okay, well, here we are. I just got to slide ahead. Again, in this case of United States versus Arvizo, and I have a link to the case down there that you can look at. In this particular case, the court said that while each of the factors relied on by the police officer viewed individually was or could look innocent and might have some level of explanation, if you took them all together, they did suffice to form a objective basis for thinking or for making the stop reasonable within the meaning of the Fourth Amendment. And you can read more about the case if you want. So, and then the last one in the list right here is going to be probable cause and reasonable suspicion. Now, the U.S. Supreme Court has classified that probable cause means a fair probability that contraband or evidence of a crime will be found. The reasonable suspicion standard, in contrast, is it's less demanding than probable cause and requires at least a minimal level of objective justification for making the stop or doing whatever it is that the officer ended up doing. So again, the Supreme Court kind of gave us a little bit of a rationale between what we call probable cause and reasonable suspicion. Now, judges have also found reasonable suspicion to justify a Terry stop in a variety of situations. And this determination is often kind of like a puzzle, where the officer tries to connect these several innocent acts together to determine whether there is in fact reasonable suspicion to justify. So again, some of these things by themselves seem okay, or you might be able to explain. But if you start to line them up and you put them together, they start to build the puzzle of criminal activity or something different, something wrong. So again, reasonable suspicion requires the evaluation, again, of the totality of the circumstance. And in the law, the totality of circumstances test refers to a method of analysis where decisions are based on all available information rather than using what we call a bright line rule or specific. Under the totality of circumstances test, the courts focus on all of the circumstances of a particular case rather than just one particular factor. So now let's look at some of these. So the following that we're going to talk about, and I think when we get through these, we'll take a short break, we'll stop, and then we'll come back with the second half. So we will divide this up into two different lectures. So the following are some factors that, in combination with other factors, have been held to constitute reasonable suspicion. The first one would be criminal activity. And these are acts that may indicate criminal activity, such as like McFadden. So when he saw the individuals casing a store, or two individuals that maybe they exchange money on a street corner. Now again, it's just one factor. But if they're in a high crime area, a high narcotics area, and someone hands over cash and you see a bag go into the other person's hand, would a reasonable person believe that maybe there's some type of illegal transaction going on? So again, that's the criminal activity part. The next one, time. These are acts that take place at a time of day in which criminal activity is likely to occur. And this may involve things like loading an unmarked van at a warehouse late at night. So you're on patrol and you drive into an industrial park area where all the businesses are closed because it's 1 a.m. and parked all the way against a loading dock way in the back with no lights is a van, and you see some people loading some boxes. And there's nobody else there. Now, there could be an explanation, but is it reasonable to stop the individuals to investigate based on what I just told you? So time of day sometimes has a lot to do with one of those puzzle pieces. High crime area. This could be, being at a location or an area that is characterized by a particular type of criminal conduct. We know that in certain areas of certain cities, unfortunately, they might have a higher level of, let's say, drug activity than in some other areas. So high crime area. Criminal record. Police officers' awareness of an individual's arrest record or record of criminal involvement. Maybe you've stopped the person before for auto theft, maybe 2 or 3 times, and they're walking around a neighborhood with a screwdriver and a flashlight. Their prior criminal record. So again, by itself, maybe it doesn't constitute a crime, but as you start to stack different pieces of this puzzle together, you're going to start to see things develop. Evasion, which means fleeing from or evading the police, running away, or driving away in a vehicle, things like that. So evasion. Non-cooperation would be not cooperating when approached or questioned. Nervous behavior. This would be acting nervous during the encounter with police. Now, understand, some people do just get nervous. They do. And that's okay, but you can really tell an individual that's super nervous, especially when they're involved in some type of illegal activity, because not only do they maybe start to sweat or their hands shake a little bit, but they look straight down, or they start to look all over the place, like they're getting ready to run or something like that. So nervous behavior. And then the last one would be experience. Remember, a police officer's experience in making arrests for the type of activity. As you gain experience, especially if you work in a specialized assignment like the auto theft detail or narcotics unit or your robbery unit, you start to gain certain expertise in areas, and based on that expertise, you can kind of look at activity and really gauge whether or not someone might be involved in that similar activity because you are an expert based on your training and your experience. And consider some cases, finally, in which courts found that the police possessed reasonable suspicion to stop a suspect. And we don't really have time to go through a lot of those. On page 86 in your textbook are 2 or 3 different cases that you could take a look at as it relates to some of those facts constituting reasonable suspicion. So let's look at the legal equation, and then we'll go ahead and we'll take a break, and then we'll come back for part 2. So when you look at the legal equation for basically the Fourth Amendment seizure of a person based on reasonableness. So you look, so we're starting here, we're on this side of the equation. So in the middle, the police officer, in justifying the intrusion, must present specific and articulable facts that, together with rational inferences drawn from those facts, reasonably suggest that a person has committed a crime or is about to commit a crime. Remember, it's the objective test. And these facts over here are to be based on the totality of the circumstances, not just one particular thing. And again, all of these facts are going to be evaluated here in the light of the officer's experience, meaning how the officer, what type of experience and training and etc. that this particular officer has. All right, so we're going to stop here at about the 47-minute mark. This will basically conclude part 1 of chapter 4 on stop and frisk, and we'll come back for part 2 of chapter 4 in just a few minutes.